morning, counsel.
Good morning, Your Honor.
All right, back on the record in the Simpson matter. Mr. Simpson is again present before the court with his counsel, Mr. Shapiro, Mr. Cochran, Mr. Douglas, Mr. Bailey, people represented by Ms. Clark, Mr. Darden, and Ms. Lewis. The jury is not present. Counsel, is there anything we need to take up before we invite the jurors to join us?
There is, Your Honor, partly because I personally represented to you yesterday that I had spoken with Max Cordoba, and because you may have heard reports that he gave a conflicting statement. I want the court to be reassured that I did indeed, about 2 weeks ago on a weekend, from Mr. Cochran's office, talk to Mr. Cordoba. Mr. McKenna was talking to him and interviewing. He called us. McKenna recognized his voice. They had spoken before. He handed me the phone just to say hello, as one Marine to another. I did that and handed the phone back. We reached Mr. Cordoba last night, and he said, yes, that's correct. I was confused when the fellow asked me the question. But the disturbing thing is that NBC would air that statement nationwide without picking up the phone to call either myself or Mr. McKenna, whom they're perfectly able to hound when they want something. They know where we are at all the time. They could have avoided this whole mistake. And that level of journalism is sinking way below what one expects of NBC, and I'm very upset about it, and I have reported it to Dateline, and I'm expecting a correction this evening when the matter is pursued. More to the point of this trial, Your Honor, you had ruled out the testimony of Mr. Coleman, who runs the ladies' wear shop next door. I believe that if one of the inferences that could be drawn from the conduct of Detective Fuhrman was a deliberate racial slur, that should be a jury question and not for the court to rule out because there are other options.
Mr. Fuhrman, would you step out, please? Well,
I'm not asking the court to change its ruling.
Let me finish hearing from Mr. Bailey.
I'm taking a legal position, Your Honor, and because what we have is a letter from Mr. Coleman, in order that this subject can be properly scrutinized on appeal, in the horrendous event that should ever become necessary, I'm asking that you give me the opportunity to put Mr. Coleman on the stand out of the presence of the jury and have him tell you exactly what happened and the way it happened, so that a reviewing court can decide whether or not you've preempted the jury from deciding a question if the question as to what the conduct meant is a factual as opposed to a legal question. Second, Mr. Coleman corroborates Max Cordoba, because after Detective Fuhrman called him a nigger inside the building and followed him out to the parking lot and did it again, Cordoba came to Coleman's place of business. Coleman remembers the incident and said, I had to calm him down. He was very upset, and he was very excited by the whole thing. Now,
Well, that's a different offer of proof.
I understand, and I'm bringing that to your attention because I learned it a short time ago when I called to see if Mr. Coleman would be available to come down and make an offer of proof on the record. That, to me, is the best possible form, and we think it would be worth the court's time to preserve it.
How about a statement in writing? I don't want to take up the court's time doing extraneous hearings all the time, counsel.
All right. Now, if you can enable me to understand, Your Honor, you have a rather elaborate statement on the first part. Cordoba, it seems to me, is a separate issue entirely.
I agree.
And his testimony would be relevant if Cordoba testifies, as he told Dateline he would last night, and is attacked on the ground that he made the incident up. Other than that, I'm not sure that a prior consistent statement would be admissible, but should it be termed a recent fabrication on Cordoba's part, and that's the drift I get from this side of the table, then the fact that he said that to Coleman hard on the heels, even if it's not part of the res gestae, would become admissible under California law. I don't think that question is going to be presented to you as to the Cordoba part unless and until that attack is made. I do think that I would like a better form, and if you're suggesting I rewrite or we put together a new, more formal statement, since those were all Mr. Coleman's words, pinpointing the issue that we wish you to take another look at, perhaps, I'll be happy to do that rather than take up the court's time putting him on the witness stand. I don't think it would take long, but I'll be happy to pursue that.
All right, I think you have the direction from the court.
Okay. Now, in addition to that, Your Honor, we have a case that we would like the court to consider. It is a court case that was thrown out because Detective Fuhrman lost a door in which a bullet hole was supposed to be, called the Gould case in the Superior Court. We believe that his conduct in that case is relevant to this one. We're going to ask you to take another look at the Britton case on which you previously ruled, perhaps with some additional facts. Beyond that, Your Honor, the phones are ringing and ringing hard. People calling in who watched the detective and now wish to offer evidence contradicting his claims. And as these people come up, as rapidly as I can, I will submit them to the court as a proffer, the way I did originally, and then await your direction as to what, if anything, must be turned over. But this is an ongoing process, and I expect it will continue for some days.
All right, thank you. Ms. Clark.
I think I'd like to play a tape for the court. Because not only did Mr. Bailey make a direct misrepresentation to the court yesterday, he's done it again this morning. And I think that the, as I said yesterday, as I predicted, the tape would be very illuminating and provide the court with some very graphic evidence of the way counsel takes his role as an officer of the court so lightly. I want to play this tape now so that the court will be reminded of exactly and precisely the language Mr. Bailey used yesterday when he sought to misinform and mislead this court as to the nature of his contact with Mr. Cordoba.
All right, Ms. Clark, what is this a tape recording of?
I'm sorry?
What is this a tape recording of?
His appearance in court yesterday, in which he stated to this court, in which he stated to this court that he had a conversation, Marine to Marine, with Mr. Cordoba, and that Mr. Cordoba told him, not Mr. McKenna, him, the statements that he later reported to this court.
You're referring to the comments by Mr. Bailey at 18606, beginning at line 15.
We don't have a transcript, Your Honor.
We don't either.
Yes, you do. (18606), starting at line 15. I'm sorry? Mr. Carpenter?
Mr. Darden and Ms. Lewis about this incident, and they shut him off. They said, we're only interested in what Ms. Bell said. And that's what he will testify to. And, Your Honor, I have spoken with him on the phone personally, Marine to Marine. I haven't the slightest doubt that he'll march up to that witness stand and tell the world what Fuhrman called him on no provocation whatsoever. As far as discovery is concerned, there is no written statement, there are no notes that I know of. And I heard about this because he called us, wanting to make it known that these people had tried to suppress this information. I spoke to him personally. I don't ever take notes, and I didn't on that occasion.
All right.
That is not what Ms. Clark says. I said I did not claim that he related the incident to me. I said I spoke to him, and I have no doubt that he'll appear. And I don't have any doubt.
All right. Why
This
don't
is
you
the kind of nonsense that gives
Wait.
lawyers a bad name, Your Honor. You know, it's very clear what he said to the court and what he was intending to convey. He was intending to convey to the court that he had personal knowledge of what this man said because this man said it to him personally, Marine to Marine. And now he's standing up and hair-splitting with us. I never said he said this to me. I just said he spoke to me personally. That's nonsense. That shows you what we have over here in the way of ethics on this side of the table. They'll get up and they'll misrepresent to their heart's content until they get caught, and then they have excuses. And then they start splitting hairs. And then they have, well, this means this, and oh, no, that means that. I feel like we're in Alice in Wonderland. We've got Jabberwocky here. Nothing means what it says it does. No means I don't remember. I don't remember means no. Same thing. Now it's coming out of the mouth of Mr. Bailey. But that's exactly what we can expect to happen when the witnesses take the stand, if we rely on his offers. And we have not been able to reach Mr. Cordoba. We need to talk to this man personally. I can assure the court, absolutely. No one cut Mr. Cordoba off. No one refused to listen to him. As a matter of fact, Mr. Darden kept it, tell us more, tell us more. Please, is that all you have? Is there anything else you want to tell us? And with respect to Mr. Cordoba's prior statements, They've been aired on national television. I mean, if Mr. Bailey doesn't know what he's said before, I guess he's never turned on his television set. But they're a matter of record that all the world has seen. So if he is now claiming to have heard something as volatile and inflammatory as what Mr. Bailey is representing, we do have some serious impeachment. But no one cut that man off. We did not have the opportunity to speak to him, so we do not know exactly what he has what he's going to say at this point. I certainly do not feel comfortable accepting anything that Mr. Bailey offers to this court, especially in view of what we've heard. And I would like to play the clip for the court from Mr. Cordoba, because Mr. Cordoba, when given the opportunity to say, I spoke with a member of the defense team, I spoke with an investigator, and then someone else came on the line, said nothing of the kind. And I think that that's something that is not a matter of our record. I think the court needs to see that, because Mr. Bailey, you can see how agitated he is, has been caught in a lie. And you know something, not in this case, you don't get away with that. There's just too many people watching.
I object to the lack of foundation for this tape. Excuse me, don't play the tape while there's an objection. If Ms. Clark is going to take the stand and authenticate the tape, let her do it. But tapes are not self-authenticating. We've had no chance to see it, as you always require, before we're allowed to show anything to you. And I'd like to know where it came from and what it represents.
It's not before you can show it to me, before you can show it to the jury.
Right.
All right, Ms. Clark, what is
I'm just showing
this?
it to the court, if you please, Your Honor. It's self-authenticating. The man on it says he's Max Cordoba.
Well, no, we've gone through the self-authenticating argument before, which I did not accept, if you recall. But, being that as it may, what is this?
This is the tape of an interview with Dateline, which was conducted yesterday after Mr. Bailey made his representations that he had spoken to Max Cordoba. After he made those representations in court, Dateline went and interviewed Max Cordoba and asked if he had had an interview with Mr. Bailey, Marine to Marine. And Mr. Cordoba said, no, I did not.
Which answer is correct?
All right. Do you have an extra copy, by the way?
He's got a new partner to solve this mystery. All new.
That's Bill Cosby, Ms. Clark.
I'm aware of that, Your Honor.
All right.
We're not offering Bill Cosby at this time. And while he's queuing it, Your Honor, if I may request that the notes Mr. McKenna surely must have taken as a responsible investigator of that interview that we now learn occurred, which obviously Mr. Bailey did not want us to know yesterday. We want the notes of Mr. McKenna's interview with Mr. Cordoba yesterday.
No, Sean.
You know, it's interesting that other states have rules of reciprocal discovery that require at least some offer or indication of anticipated testimony in their reciprocal discovery statutes, which is something California does not have.
I find it interesting, though, that it would appear the investigators for the defense in this case have prepared reports and taken notes on all other witnesses, but surprisingly, nothing on this one.
Well, I assume that's something you'll cross-examine on.
Probably fair to assume. Well, at least Mr. McKenna, a witness at the very least.
And Ms. Clark, who tape recorded this for you?
Suzanne? Our Media Relations Department did, Your Honor. After contacting Dateline to find out when the interview was conducted.
And are you representing to the court that this is a videotape of the Dateline broadcast when?
Last night, Your Honor. This is a videotape of the Dateline broadcast last night, an interview that was conducted with Max Cordoba after Mr. Bailey's representations to this court yesterday concerning his contact with Mr. Cordoba.
Is that Max Cordoba? That he'll march up to that witness stand and tell the world what Fuhrman called him on no provocation whatsoever.
No, I have not talked to F.B. Bailey.
If you believe Max Cordoba, and the defense hopes you will, then Simpson's defense team has some explaining to do. Because today, in our exclusive interview, the ex-Marine and potential witness said he didn't know what F. Lee Bailey was talking about. That if he'd spoken to the famous attorney, he'd remember, and he doesn't. Never talked to him.
No.
You know who F. Lee Bailey is?
Yes.
Pretty distinct fellow.
Yeah.
Pretty distinct voice.
Correct.
So you haven't talked Marine to F. Lee Bailey.
No.
But Cordoba told us he does remember talking to Fuhrman, and what he now says Fuhrman told him ignited a heated debate today in the courtroom.
Max Cordoba wanted to tell Mr. Darden and Miss Lewis about this incident, and they shut him off.
By the way, that representation will be disproven as well. Now, Mr. Cordoba had the opportunity to say, well, yes, I had some brief conversation with Mr. Bailey, but we didn't discuss the content of my testimony. Or, yes, we had a brief contact. He said hello to me. Mr. Cordoba said none of the above. He had the opportunity as well to say, Mr. McKenna spoke with me. I know he's a defense investigator. He did not say that either.
All right, Ms. Clark, let's assume, for the sake of the argument, that what you say is correct, that this misrepresentation has been made to the court. What action or sanction do you seek as a result?
I think that the witness should be precluded from testifying. I think that Mr. Bailey should be cited for contempt and fined substantially. As an officer, an officer of the court, he has lied to this court. He is impeached by his own
I ask
witness.
that you put a stop to it. Either
Mr.
put
Bailey.
Cordoba on the
Excuse
stand
me, Mr.
or
Bailey.
stop her from
Mr.
testifying.
Stand up and speak when it's your turn.
Mr. Bailey, do not interrupt counsel. I understand this is a volatile issue, but it's a big problem for the court. I'd ask you to control yourself, sir. Ms. Clark.
I think that what has occurred is very serious. And I think that the interview with Mr. Cordoba makes it's very stark. There are no gray areas here. This is not a matter of hair splitting anymore, as Mr. Bailey got up to represent to the court this morning. Mr. Cordoba was confronted with the statement that Mr. Bailey made, that they spoke. He said, no, we did not, and I would remember. And there was the opportunity to say we had some conversation, and he did not do so.
All right, thank you, Ms. Clark. Mr. Bailey, do you wish to respond?
I do, Your Honor, and I do not appreciate being called a liar in any court, and I will ask at the proper time for correct action to be taken against the offender. The proper way to proceed, if there was any claim of misleading the court, would be to put the witness on the witness stand under oath and let him be questioned in the court's presence. What they eliminated from the tape that I saw on NBC News this morning was that Stone Phillips said, why didn't you mention these things before? He said, I only give very narrow answers to every question. As he explained to Mr. McKenna last night, he did not have an interview with me, nor did he tell me his story. When he was talking with Mr. McKenna in the office, Mr. McKenna handed me the phone to introduce me, and I said, Max, as a Marine, I'm proud that you have the courage to come forward and say this. I know that it's painful. And he said, I'm willing to do it. And my comment to the court was in response only to the unfounded, irresponsible, and false assertion by Ms. Clark that Cordoba would never appear. She had no basis to say that whatsoever, as she has just shown with her own videotape. Now, I expect NBC to correct it, and somewhere down the line, I hope that this court record is made plain. Mr. McKenna is sitting right here, and he is available to get on the witness stand and assure the court that Max Cordoba said last night, okay, I now remember I spoke briefly on the phone. That's not an interview. Phillips could have saved himself some embarrassment if he'd bothered to pick up the phone and call me. NBC always finds me when they want to.
I am concerned, though, Mr. Bailey, that the statement, "I have spoken with him on the phone personally," Marine to Marine, that sort of connotates something more than just, "Hi, how are you? I'm glad to talk to you."
I don't understand why you're concerned. You raised no question about what was said. I was simply, if you were reading the transcript correctly, giving you my assurance that I expected him to appear when called, that he was under subpoena, and that I did not think he would vanish, and that I had spoken to him and received an assurance on that alone. I do not interview witnesses. Good lawyers generally don't. They might be in a position of having to testify if the witness were to accuse them of something or tell a different story. Mr. McKenna is employed for that purpose. We happened to be in the same room when Cordoba called us, as his phone record will show, if he has made the call from a private phone and was billed for it. Now, you're perfectly able to explore this right now with Mr. McKenna, and I wish you would. And if you read the transcript carefully, I was reacting to the only thing that concerned me, because an offer of proof is an offer of proof, and the court has to accept it as that. But the court might be concerned that if cross-examination were put forth and the witness never appeared, that the damage would be done and you couldn't unring the bell. And it was my purpose to assure the court that I felt this fellow would appear based on his statement to me that he would. And that's all that transcript says, and you can't read it any other way. If you got a contrary impression, I'm sorry. That was not my purpose. I wanted you to know that I believed he would appear, or I wouldn't put the questions. And that is the sum total on the subject.
All right. Thank you, Mr. Bailey. All right, counsel, we have an interesting situation here, not unexpectedly. Counsel, what we're going to do with regards to Mr. Cordoba. Ms. Clark, where does Mr. Cordoba reside?
I'm sorry?
Where does Mr. Cordoba reside?
He's not in the state, or he wasn't last night. We were unable to contact him.
What state does he reside in, Mr. McKenna?
He's not in California, I don't believe, today. He resides in Bellflower, if that's a town. He has a subpoena.
When did he leave?
I believe he left either this morning or last night.
And when did you speak with him?
I spoke to him.
All right, Ms. Clark, I agree with Mr. Bailey's comment that television news broadcasts are not bases for the court to preclude at this time the offer of Max Cordoba as a defense witness, unless and until I hear testimony from Mr. McKenna and Mr. Cordoba himself regarding these issues. I think you agree with that. So at this point, I'm going to preclude any cross-examination regarding anything with regards to Max Cordoba, which I had previously done, but I'm going to extend that prohibition through the remainder of Detective Fuhrman's testimony. Under the California Evidence Code, a prior inconsistent statement may be offered as long as a witness has not been released from the requirement of providing further testimony under 770 of the Evidence Code. So if it should transpire that Mr. Bailey is correct in his assertions, then perhaps we will hear from Max Cordoba. But unless and until I'm satisfied that the offer of proof there is a sound basis for it, I don't believe Max Cordoba will surface. But I'll determine that at a later time.
Okay, thank you, Your Honor. Mr. Darden needs to address the court on the matter of Alwyn Martin.
Well, I was going to ask whether I could ask questions about Alwyn Martin, because they had a tape-recorded interview with her last night, we're given to understand. But I would like a clarification of what the court is saying. You don't know whether Max Cordoba is going to surface because you don't know if he will repeat what he said on television?
No, what I'm saying is that as far as this controversy
Yes.
that has since arisen, I'm not going to allow any cross-examination with regards to anything Max Cordoba might or might not say unless and until we hear from him first, because there are some issues we need to resolve before he hits the witness stand in front of the jury, is what I'm saying.
He's in New York for 4 days, I'm told.
Well, I suspect the defense case won't start any time between now and next week.
Are you saying that you will postpone examination of Detective Fuhrman on the Cordoba issue until the defense case has begun?
That's correct.
Well, I strongly object to that, Your Honor. You have the power to get Cordoba in here while the prosecution's case is going on and hear from him and make your preliminary findings. But to put it that far down the road is completely unfair in the cross-examination of this critical witness.
Well, counsel, I didn't create this problem.
I didn't create it either, Your Honor. We interview witnesses, we make proffers to the court, and that's all we have done. We subpoena witnesses. That, too. I didn't interview him for Dateline or ask him to talk to Dateline. Nor did I confuse him as to whether or not he'd ever talk to me. What are we being penalized for? I don't understand.
You're being penalized at this point merely under the procedure of the California Evidence Code, which says prior inconsistent statements can be offered in one of two ways. Either the witness is confronted or the witness is still available to be cross-examined. And that's how we're going to do it. Thank you, sir.
All right, no more objection, please.
Noted. Mr. Darden.
Good morning, Your Honor. Your Honor, the people would like to lodge a 352 objection to the admission of any information relative to Detective Fuhrman's contact with Alwyn, A-L-W-Y-N, Darla Martin. Ms. Martin was the victim of a carjacking on May 20, 1993. During the commission of that assault and robbery, she apparently was stabbed. She was taken to the hospital where she was treated. She was taken to surgery. 2 days later, Detective Fuhrman visited her at the hospital, as I understand it. When he walked into the room, Ms. Martin's boyfriend was there. Ms. Martin is Caucasian, as I understand it. Her boyfriend at the time was African. I think he was British, actually, so not necessarily African-American, but of African descent. Detective Fuhrman met him. They shook hands, introduced themselves, and Detective Fuhrman had a conversation with Ms. Martin relative to the description of the carjacking suspect. Last night, one of our DA investigators, Brian Hale, interviewed Ms. Martin. Ms. Martin could point to no racial epithet uttered by Detective Fuhrman. She could point to no racial slur. Detective Fuhrman did not tell her that only blacks or African Americans commit carjackings. Detective Fuhrman did not tell her that he disliked interracial couples or that race mixing was a crime against nature or anything of that sort. We've reviewed the file, the investigative file in this case. There's nothing in the file to indicate that Detective Fuhrman harbored any type of hostility or animosity toward Ms. Williams or her boyfriend because of their relationship. There's no evidence. I'm sorry, Martin. There's no evidence, no indication, no firm evidence, no firm allegation by the witness, Ms. Martin, that Detective Fuhrman has done anything but act professionally. I don't know why the defense wants to introduce this incident or this contact, but I can assure the court that there is nothing here which suggests that Detective Fuhrman harbored any racial animus or bias against Ms. Martin or her boyfriend because of their interracial relationship. I'm at a loss to explain or understand why they want to introduce this. It shouldn't come in. It just shouldn't come in. I'm sure that once counsel begins asking his questions relative to this issue, and once he puts his own spin on it, that perhaps he can somehow transform it into a racial issue. But based on our conversation last night with Ms. Martin, there is no racial issue here. There's no evidence at all that Detective Fuhrman acted in any way other than as a professional police officer.
All right, Mr. Bailey.
First of all, I'd like to hear the tape. Mr. Darden has chosen not to confront the offer of proof in any way. You were never told in writing or in any oral description by me from this podium that racial epithets were used or any of the other things he's attempted to negate took place. What you were told was that Detective Fuhrman was assigned to investigate a stabbing and a robbery of an automobile. That pursuant to that assignment, he came to the hospital to interview the victim, who had been injured in the stomach with a sharp instrument. that she told him the assailants were white, that he suggested that they may have been light-skinned blacks, and when she refused to budge on that issue, he left the room, filed no report, and never returned. That was the offer of proof. I have not heard that contradicted. But because we're having these problems, I would suggest that the court listen to the tape that was made last night and that we make it part of the record. If you're relying to any extent on his interpretation of what he thinks someone else heard from Miss Martin, the court needs to hear it directly. And then if the offer of proof is somehow improper, you have a chance to catch it right now. But the tape is the best evidence, not Mr. Darden's spin on that tape. And I think we should hear it.
Mr. Darden?
I'd like to hear their tapes, Your Honor. Our tapes are impeachment evidence. I don't know what Mr. Bailey has been reading, but apparently he hasn't read the complete police file in this case. Detective Fuhrman did file a supplemental report. And not only did he file a supplemental report, he also took to Miss Martin a mug book containing many, many white arrestees and potential suspects, all Caucasian. Detective Fuhrman did his job, Your Honor. Now, he questioned Miss Martin apparently about her description of the suspect, as any detective would do. Where's the racial issue? Yeah, there is none. Mr. Bailey perhaps should get the rest of the police file in this case, and once he does, he'll see that Detective Fuhrman attempted to run down partial fingerprints recovered from her vehicle. He took her mug books. He looked at other reports, okay, to see if there was some type of MO between this carjacking and others. He did everything a police officer is supposed to do in a case like this.
Have that file here, or a copy of it?
I have a copy of the supplemental report.
Your Honor, might I point out that Miss Martin called Detective Tapia, the West Los Angeles Police Department, to ask for the report, and he sent her 2 pages and said that's all there was. Furthermore, I'm startled to learn today that the prosecution has so many facts on the Martin case. They were very silent about them yesterday when we first discussed this issue. Perhaps this is something that Detective Fuhrman never mentioned until after we talked about it.
You know, we weren't particularly concerned about the Alwyn Martin case, Your Honor. Why should we be? There's no issue of racial animus contained in this case. At any event, before counsel stands before the court and makes these allegations of this nature, he ought to check out the facts. He ought to know what he's talking about. In addition, Your Honor, LAPD does not turn over unsolved supplemental investigative reports to victims or to anyone. This case is not closed. This case is still an open case. And I would ask the court to direct counsel not to distribute the supplemental report to anyone, and that no copies be made as well. There was a partial fingerprint recovered from the victim's vehicle, which at some point may be matched to a particular suspect or defendant. In addition, Your Honor, when, as I understand it, when Ms. Martin contacted Detective Tapia at West LA Detectives relative to this report, she mentioned to Detective Tapia that Detective Fuhrman had done a good job and that he had acted as a true professional during the contact that she had with him. If I can stay further, Your Honor, I don't want to have a mini-trial on racial issues, Coleman and Martin and Cordoba and all of these other people. I don't want to have to call 25 witnesses in this case just to rebut these malicious allegations the defense has launched against Detective Fuhrman. And we shouldn't have to. At some point, this becomes cumulative. At some point, 352 has to come into operation and cut the defense off. Okay? I mean, this is ridiculous, and it's going to result in a mini-trial. And the jury shouldn't have to sit here an extra 2 weeks, and I shouldn't have to sit here an extra couple of weeks to litigate these collateral issues. Every contact everyone had with Detective Fuhrman, is a case of racial animus or reflects some racial bias on Detective Fuhrman's part, Your Honor, especially this one. It looks like good police work here. Nothing more, nothing less.
If it pleases the court, it would have been much nicer if Detective Tapia had been truthful to Ms. Martin and said there is more of a report that I can't give you. She was given to understand that the 2 pages were all that ever happened, and from that we do quite properly an inference that there was no follow-up. But all that aside, Ms. Martin came to us because of Detective Fuhrman's conduct. She described it as we have described it to you. That was the offer of proof in camera, and that's the offer of proof as it exists today. If she made statements about Detective Fuhrman being a nice fellow, doing a good job, that's perfectly available for impeachment. But the evidence about trying to suggest that a white suspect, very clearly white in this report, might have been a light-skinned black, was what brought the whole matter to your attention to begin with, and I've not heard that controverted yet. I would like to have marked, however, Your Honor, because the subject is still very much alive, a document that just came over the fax from Phil Coleman, and I'd like Your Honor to read it.
I'm not going to deal with Mr. Coleman at this time, Mr. Bailey.
It deals with Mr. Cordoba.
That's a closed issue at this point.
Cordoba is a closed issue until the defense begins,
Correct.
and we're not allowed to address Your Honor on it again.
I'll allow you to, but not today. Don't press it. My concern, counsel, is now I have a report that's dated June of 1993, which clearly indicates that the suspect was white, clearly indicates that the suspect stated, the male white suspect, it clearly indicates a suspect description. It's signed by Detective Fuhrman. It indicates a inquiry into other possible connections that might be a factor in the robbery. Indicates the recovery of the vehicle, the garnering of fingerprint evidence, and the detective taking mug books to the victim for possible suspect identification. This is contrary to the offer of proof.
And withheld from the defense.
Well, this is a defense witness that was
Defense
brought.
witness has no access to police reports, particularly when she's told they don't exist.
All right, I find the offer of proof to be clearly contradicted. Prosecution objection will be sustained.
Your Honor, if I can be heard, relative to the issue of the follow-up
And I'll mark
investigation.
this as Court's Exhibit 7.
Your Honor, would the court kindly order defense counsel to return the supplemental reports to the court, and would the court seal the supplemental reports?
Yes.
May I have this document marked for identification?
You may. I will read it. Hand it to the clerk. Let's have the clerk make photocopies for counsel. Any other comment before we invite the jury to join us?
Yes, Your Honor. A couple of matters that may arise. I thought I would preview them for Your Honor rather than have to go to the bench in the middle of cross-examination. I have purchased a light which I believe is identical, or at least very similar to the one that Detective Fuhrman has described repeatedly in his testimony.
You described it as a AA, 2AA mag light, which that appears to be.
Yeah, and I would simply like to know from him before the jury comes in whether it is a replication so that it would be fair to use it in cross, in asking where he was holding it, where it was kept. I also have, which does not purport to be the same size or manufacture, a brown leather glove in a Ziploc bag that I would like to refer to in cross-examination without suggesting that it be marked as evidence unless the prosecution wishes that be done, as with the flashlight. The third item is I intend to ask Detective Fuhrman to name his 3 best friends. And I intend to do that in reliance on your ruling that that was a proper question for Rosa Lopez. We would like to talk to those friends.
Ms. Clark? Certainly.
If it please the court, we tried to locate a copy of the Help Fuhrman letter that was referred to in the testimony. We have been unable to procure one. We have its contents described in this article which was sent to us from Oklahoma. And as I understand it from Mr. Fuhrman, he has some knowledge of the letter that went out. I believe that if he does not have a copy with him, his lawyer, Mr. Tortolo, who, as we speak, is, I believe, on the 12th floor, prepared to watch his testimony, and I would like to request that the prosecution attempt to make that letter available before the cross is concluded. I would like the court to take a look at the basis of my request, which is this article.
Well, I think if Mr. Tortolo is on the 12th floor, I could ask the public information officer to go up there and see if Mr. Tortolo has a copy of that available.
I think we just asked him.
Ms. Hazlett? Thank you.
I have given a copy of the article, please, the court to the prosecution.
With respect to the flashlight, Your Honor, no objection. With respect to this plastic bag, this is ridiculous. The Ziploc bag, for which there's no no connection to this case. A leather glove of a different size, a different color, a different make, a different style, that has no relevance to this case either.
May I see that?
Yes.
Thank you. When you say different size, what do you mean, Ms. Clark?
Obviously smaller. It's like my size. And I think counsel even conceded that it's a different size. This is, under 352, there is no valid probative purpose to this. I'm sure the court knows that what Mr. Bailey again intends to do is make another inflammatory argument with no evidentiary basis whatsoever in an attempt to confuse, mislead, and deceive this jury. This has no part in any search for the truth. This is a fantasy woven by the defense, for which there's no evidentiary basis, no logical or factual connection to this case.
Let me ask you this. What is the glove size that is on the glove that was recovered at Bundy?
Extra large.
glove there is a Brooks Brothers size small.
Right.
They're out of extra large, Your Honor.
Not only that, but the glove in issue is an Aris, and it is not a Brooks Brothers. Can't even tell if it's a man's or woman's glove. Size small. I guess it's Mr. Bailey's. I don't know what the relevance is to this case, Your Honor. I can't see any possible valid evidentiary purpose for the admission of such an item that bears no resemblance to the gloves in this case, or a Ziploc bag that has no, absolutely absent from this case, no such evidence in this case whatsoever. And I think that the court should prevent these kind of theatrics that are misleading and inflammatory and deceptive in front of this jury.
What's your comment on the letter regarding Detective Fuhrman?
With respect to that, I'd object to the admission of the article. With respect to the letter itself, I have a real difficult time seeing the relevance of that, Your Honor. Detective Fuhrman has sought legal assistance for the purpose of defending himself as a result of the malicious attacks that have been made on him by the defense. In that regard, his lawyer attempted to defray some of the costs of his legal expenses. This was not a letter drafted by this witness, by Detective Fuhrman. It was a letter that went out by his lawyer that this witness apparently is not even familiar with enough to say what's in it or not in it. So that alone, I think, should preclude the use of it. I don't see its relevance in this case. It does not show any financial interest in the outcome of this case that would be relevant to bias. So I think under 352, that letter is of no probative value at all. I should also indicate that Mr. Bailey has given us no proof, no offer of proof even, as to how Detective Fuhrman, which I'm sure is the inference that he wants us to draw, put the glove that he found at Rockingham into a plastic bag. There's no offer of proof. There will never be any proof. There will never be anything but Mr. Bailey's theatrics, dramatic, albeit eloquent statements to this court that are absolutely empty of any evidence or any factual support. And that is why he is seeking to take a different pair of gloves, different style, different size, in a Ziploc bag that this case does not contain. There is no Ziploc bag in evidence in this case. He's manufacturing evidence. He doesn't like the truth. So he's manufacturing his own. And that's what this is all about. And that's why this is the kind of thing that should not be permitted. May I have a moment, Your Honor?
Certainly.
Let me ask, is the court inclined to allow in a newspaper article, or is the court going to seek to allow, or is the court going to allow counsel to use the actual letter?
I don't know yet.
Or neither?
I don't know yet.
You don't know yet. I think that as far as the letter goes, I think we've gone as far as we need to go. Detective Fuhrman indicated he was aware of the letter. He did not draft it. He's unaware of the precise contents of it. It was an article drafted by his lawyer. But counsel has received the admission from Detective Fuhrman that he sought. Yes, with respect to the letter, I think, no, I've said it. With respect to Detective Fuhrman and the plastic bag and the glove that counsel now wants to admit, there is absolutely no evidence that Detective Fuhrman put anything in any plastic bag on any time relevant to this case, June 12th, June 13th, or June 28th, or July, August, September, October. None. And so there is no valid purpose for the admission of that non-evidence.
All right. Mr. Bailey, any brief response?
May I respond to that, Your Honor? I take it there's no issue as to the three good friends. Just a couple.
Yes. Oh, I'm sorry. I forgot to address that. Allow me, please, counsel. With respect to the three good friends, Your Honor, number one thing, we have a privacy issue as to those three people. I wonder if it's fair to have their names aired publicly for no valid purpose. With respect to the cross-examination of Rosa Lopez, I mean, this seems to be this kind of like a petty tit for tat. You did it, so we get to do it. They obviously don't understand. Mr. Darden was cross-examining Rosa Lopez because she claimed to have witnessed something very important, very significant concerning this case. And obviously, it would be logical for one to expect that she would tell that very significant observation and experience to her closest friends. And so that went to an important area of impeachment. What is the valid purpose of inquiring of Detective Fuhrman who his best friends are? There is none. This is just a petty, vengeful kind of tactic employed by the defense. If the court is inclined to allow for this kind of nonsense, then at least allow Detective Fuhrman to write them on a piece of paper and allow counsel to see those names.
That's
but I think there is no valid purpose for this. I really think it's just a petty, ridiculous kind of form of payback by the defense. There is no valid evidentiary purpose to it, as there was in the cross-examination of Rosa Lopez. I would like for counsel to perhaps give this court an offer of proof as to the relevance of Detective Fuhrman's three best friends.
But I suspect Detective Fuhrman's three best friends would be proud to be stand up and be counted.
I'm sure they would, Your Honor. I just want to give them the option of doing so. But if counsel wants to, you know something, as the court is well aware.
Why don't you ask Detective Fuhrman if he has any objection?
I can.
And I would suggest, this is something that in most cases they're entitled to look into. Obviously, the people you want to talk are the people who know the person the best.
Right.
If Detective Fuhrman has no objection to revealing that privately to you and to counsel for investigation purposes, then it's a non-issue.
I'll be glad to handle it that way. It's just that, we are all sensitive to the privacy issues that have been
indeed.
foisted upon us, and I just
Indeed.
don't want to do that without anybody's say-so ahead of time.
All right, well, let's pursue it that way.
All right.
Your Honor, the letter Mr. Bailey alluded to a moment ago is here, and the clerk is making copies of that letter.
All right, thank you. Mr. Bailey?
Let me address the other issues and save that one until I get the letter.
All right.
To actually see it, the transcript, if it pleases the court, at page 18, 750 and before, shows that the witness knew about the letter. It was unclear as to his understanding of all of its contents. The flashlight is solved.
Yes.
Let me state very clearly, and I should point out that if Ms. Clark thinks that hand and this glove would ever work together, her eyesight is as bad as her memory. But Marines, if it please the court, have a habit, most of them acquire, as to where they carry things because of the nature of their duties, drills and activities, and the nature of the issued garments that they wear. The prosecution has opened this door rather deliberately, knowing full well that there would be questions as to whether or not the someone, and there has to be someone, who transported that glove to Rockingham could have been Detective Fuhrman. They were at pains to have Detective Phillips say that he never wore a coat or almost never wore a coat, suggesting that he would not have had the means to conceal the suspect glove had he acquired it. A generous offer would be to use both, the bulk of which exceeds the large glove that will be in evidence if they ever get through testing. The plastic bag, I think, is reasonably similar, and the witness can tell us, to those contained in the homicide kit in the car that he was driving that night, or riding in. The rubber glove, which is here for a different purpose, is similar to the one that we have seen on Detective Lang and that Detective Fuhrman said was in the homicide kit and available to him. We have suggested that he has described with great differences a key trip to the body of Ronald Goldman. We suggest that most killers don't leave one glove at the scene and carry the other one to private property under any circumstances, and I suspect that every detective who's asked if he's had that experience will have to say no. So the likelihood is that when the killers left the scene, both gloves were there or both would have been taken. You have seen that the one glove which is admitted in evidence was under some leaves and not easily visible until the leaves were poked back. Detective Fuhrman described that as leaves cascading down over the glove and partially blocking the view of it. Assuming, since that glove is right against the fence, that the other one was seen several feet away from the vantage point on the north side of the fence in the shrubbery, where it would not be immediately visible unless specifically looked for with a flashlight. If that was spotted, even with this little light, which throws a pretty good spot for a short distance in darkness, how was it transported to Rockingham? Certainly the prosecution is going to ask that question. If it were placed in a bag, which would explain the reason that it didn't dry, and we will offer evidence to this court that had it been sitting out in the air at 60 degrees under the conditions which existed that night, it would have dried, and that will be given by someone who has seen the glove and the amount of blood on it and is an expert in such matters. So, one way to explain its failure to dry would be to have it sealed off from the air. Detectives frequently, as we have seen in this case, collect evidence in plastic bags, something you are never supposed to do if you're dealing with blood, because everything that plastic bags do, as you will recall from an incident in the courtroom, to bloody objects is bad for evidentiary and detection purposes. Marines tend to carry things in their socks, the same way some detectives carry an ankle holster for a backup weapon. This package could easily have been kept in a man's sock, short or tall, for the length of time that would have been necessary from the finding of the glove, if it occurred when we believe it did, on his visit to the north fence, described in dramatically different ways on two different occasions, in ways that can't be reconciled. It could have been concealed up to the time that he bolted out of the house without telling anyone and making sure everybody else was occupied, and for 15 minutes did something which we believe explains the presence of the glove, the blood in the Bronco, etc. And we ask Your Honor to note that this man said that for 5 to 7 minutes he investigated the side of the house, wondering who dropped the glove and where he had gone, and failed to notice a set of steps and a door leading into the house. If that does not contradict any possibility that he occupied his time as he says, I can't imagine a stronger contradiction. A door is hard to miss, and Mr. Fuhrman has experience with doors, as we will show you in the Gould case. Now, based on all that circumstance, I think it fair to ask Detective Fuhrman if it would have been possible for him to put a glove in a plastic bag to which he had access and to stick it in his sock and to later pull it out and dispose of the plastic bag. Not a complicated question, not one he'll have trouble understanding, but a fair question, it seems to me, because at the end of the day, the jury is going to have to decide between the choices given them, whether this defendant jumped over a fence or did something unreasonable and dropped a bloody glove on his property, whether a killer wishing to divert the police, and if this happened, he was eminently successful, from any attention to him, deposited the glove simply by throwing it over the fence, as is easy to do from the property where Rosa Lopez lives, or whether Detective Fuhrman, who well could have, and had the motive, and we say the opportunity, carried that glove, from where he found it at the crime scene and deposited it in a way that would accomplish two things. Number one, it would keep him inexorably in the lawsuit, and number two, it would punish a black man who had the temerity to associate with a white woman in a romantic way. Now, that's the theory of the case, and I think that the evidence that we're offering to support it ought not to be excluded. I think the question goes to the weight. If Detective Fuhrman wants to say, the kinds of socks I wear are so fragile that they wouldn't have carried the package, that may be his answer. The question is, are we entitled to ask? As to the letter, I'm holding, I believe, does the court have a copy?
Yes.
All right. It is a letterhead specially made up for this case, and it says Mark Fuhrman Justice Fund. It seeks financial contributions, and I respectfully suggest, Your Honor, that it's admissible for several reasons. First, Detective Fuhrman knew about it, and it was to his financial advantage if others would pay his legal bills so that he wouldn't have to. Number two, unless and until Mr. Tortolo can provide some evidence that the expenses, not fees, but expenses of handling Mark Fuhrman's representation in this case had caused him to spend $100,000 of his firm's money, as this says, then he has committed a rather neat violation of Title 18, Section 1341, mail fraud, by trying to induce people to pay money on the ground that $100,000 had been spent. And if Detective Fuhrman knows how that money was spent in representing him, in this case by Tortolo and Butler, I think he should be able to tell us. And if he doesn't know, then he should tell us whether or not he ever questioned this assertion before this letter was put in the mail to his fellow police officers to induce them to depart with their hard-earned income. I think that would be fair cross-examination, and that is the basis for further questions about this letter.
All right. Ms. Clark, you want to address just the letter, please?
Only the letter?
Yes. That's the only thing that we haven't discussed.
Now that I've finally read the letter, Your Honor, now I'm really stumped as to the relevance. I cannot see how, I mean, counsel has already gone into the existence of the letter. Probably should not, I should have objected to it at that time. And now that I see the letter, I can tell the court, absolutely, I do not see the relevance of this. Detective Fuhrman has an attorney who is representing him. This does not give Detective Fuhrman a financial interest in the case. This is supposedly to defray costs, but it's really gotten way off the end of the scale of relevance. What is the probative value for which it's been offered? I haven't even heard of a theory proffered by counsel that would make this relevant to Detective Fuhrman's credibility. This is a letter drafted by his lawyer. He was aware that such a letter was drafted. He himself did not draft it. He himself received no money as a result of it. As a matter of fact, the understanding I have is that there has been no money received as a result of this letter. I think that there's simply no relevance to this. There shouldn't have been cross-examination. As a matter of fact, what the people would like to do is simply ask the court to strike the questions and answers that have already gone and pertain to this letter as irrelevant, and not admit this letter itself, which is the height of irrelevance. I don't see the probative value with respect to the testimony of Detective Fuhrman.
All right. Thank you, counsel. All right. The issue before the court is what can counsel use with regards to these items for the cross-examination, continuing cross-examination of Detective Fuhrman. There being no objection to the flashlight, the mag light, that will be allowed. Court will sustain the prosecution objection to the use of the gloves for this reason. The glove involved in this case is an extra large glove. Its specific bulk and dimension, as mentioned by the defense theory, is therefore critical to how it could be transported by Detective Fuhrman, given his garments that particular evening, how he was dressed, and what means he had available to him. I will preliminarily allow the plastic bag, however, to be used if, Mr. Bailey, you can establish a foundation that a similar bag of similar size was available to Detective Fuhrman in the homicide kit. And as to the letter, I'm going to reserve judgment on that. I would like to read it sentence by sentence, and I don't have the opportunity now. I'd like to at least proceed with what you have left with the jury this morning.
That's fine, Your Honor. I take it you will go to 12 and perhaps be prepared to address these matters this afternoon if we're still going. All right, well, in the event I should conclude cross with the postponements that confront me, and redirect is begun because you wish to use the jury's time profitably, I would like, once you have ruled, to be able to come back and complete the cross.
Yes, as to this letter, this letter, correct.
Last matter, Your Honor, the letter that was furnished to me, and this may be a copying fault, is blurred on the line that recites the amount claimed to have been expended.
It does. It does on my copy as well.
Do we have a copy where the figure 100,000 is clearly shown?
Mr. Bailey, the copy delivered to me this morning in court, and
Can we agree it's 100,000, or should we get the original from?
let me make a call.
All right, well then, all the more reason to delay recross as to this issue.
It's over 100,000 in the exact words.
All right, well, let's get a clean copy of this, if it's available.
Your Honor, may I make inquiry of the prosecution as to whether either the left or right-handed glove that was actually involved in the murders, we believe, is accessible? The reason I tried to buy one is because we have told they were still being tested somewhere, but it seems to me if either one is available, the bulk would be sufficiently similar to make the question fair.
But this is a Eris brand gloves are commonly available. I mean, that's a major brand of gloves. I assume a similar glove is available commercially.
I thought this was Dan Marino's glove, the Isotoner or something like that?
Ms. Clark, what brand is it? I thought you told me it's Eris.
Eris Isotoner, okay.
Broadway.
Well, if we can get an extra-large glove not used in the murder, would that be fair?
Yes.
All right.
It's the bulk that's the issue. And if you use
McKenna,
a small...
I don't have to tell you where your duty lies.
All right, thank you, counsel. Let's have the jurors, please. Madam Reporter, are you okay? Or the delay in getting started this morning, there were a number of issues that I had to deal with this morning so far, perhaps 20 different issues that we've had to address and I've had to make rulings on or make determinations and discuss things. And as luck would have it, it just takes a long time, some of these things. And I just want you to know that while you're back there, I'm aware that you're back in that small little room and it's not the most comfortable place in the world. And I do have in the back of my mind constantly the pressure knowing that you're back there. But there are just some things that I have to determine out of your presence, and they got longer than I thought they would today. All right, Detective Fuhrman, would you please resume the witness stand, please? All right, Detective Mark Fuhrman is back on the witness stand, undergoing cross-examination by Mr. Bailey. Good morning, Detective.
Good morning, Your Honor.
You're reminded you're still under oath. Mr.
Yes, sir.
Bailey, you may resume.
Detective Fuhrman, yesterday you told us about a certain time that you were in a grand jury room with other lawyers whom you named. Have you been able to recall the identities of any of the other people that you were unable to name yesterday who were present during this exercise?
No.
Okay. And I take it you've made no inquiry as to who they were then?
No, I haven't.
Is this the only time that you were questioned in a modified court setting, so to speak?
Yes, sir.
How many other conversations did you have this year, I take it they were all this year, with Mr. Darden, Ms. Clark, Ms. Lewis, or other prosecutors about the forthcoming testimony?
Several conversations. I'd have a difficult time on numbers.
We have the same difficulty with the word several, okay? If you could use numbers, it would be much more helpful to us. Were you engaged in at least 10 different visits with the prosecution in preparation for this case, including the one in the grand jury?
I think that'd be the high number. I don't think it'd be that many. I'd feel more comfortable with maybe 8.
8 you think would be more accurate?
Yes.
And does that include this session that you described?
Yes.
Okay. Now, the subject matter of the session with the 3 lawyers was the Kathleen Bell problem, you told us.
Yes.
And that was the sole purpose of this simulated cross-examination?
To the best of my knowledge, yes.
Okay. Do you have any understanding of how the questioning that was done to you was to alleviate your concern over remarks you say you never made? What was the plan? Can you explain that to us?
No, I can't.
You can't.
No.
Well, were you told why you were being brought into that room?
To be confronted with cross-examination type questions
All right, but I'm sure it was more explicit than that, wasn't it?
concerning Kathleen Bell.
Concerning Kathleen Bell.
Yes.
All right. And were you told what they were hoping that you would do or not do when questions were put to you?
No.
Did any of the questions contain the name Kathleen Bell?
I don't believe so. I'm not sure on that, but I don't believe it did, no.
Did it contain the name of any other living person related to this case?
No, not that I remember, sir.
How many total questions do you say were put to you to address the Kathleen Bell problem?
Not very many. It'd be hard to estimate. It'd be also less than 10, I'm sure.
Less than 10.
Yes.
3 lawyers asked you a total of 10 questions?
There was a lot of discussion between the lawyers. It just wasn't questioning.
My question was, do you represent to this court and jury that 3 lawyers asked you a total of 10 questions in this session?
Yes.
That would be 3 and a fraction per lawyer.
Yes.
Do you know any lawyer on this earth who is capable of asking only 3 questions?
Not currently.
Touche. Detective Fuhrman, how was it possible for these people to prepare you to confront the Bell problem, whoever brought it to your attention, myself or another lawyer, without using the words that you were claimed to have used in her presence? How did they do that?
I read some allegations. I believe it was on a declaration.
All right. Did you have in front of you a document filed in this court, signed by Kathleen Bell, alleging the conduct that we discussed before the close of court yesterday?
So are you talking about
Oh,
what I viewed on the
Yes.
that letter in front of me? No. I did not have
No,
that.
I'm talking about a declaration that was filed in court by Kathleen Bell as an offer of proof.
On that day?
sustained. Nothing was filed by Kathleen Bell in this court.
I'm sorry, not by Kathleen Bell, in her behalf as to what she would say.
In front of me that day, sir?
Yeah.
No.
What paper were you looking at that was the basis of the questions? Could you
I
tell
was
us?
looking at no paper.
I thought something was read to you or that you read that you called a declaration. Can you tell us what you meant by that?
I had read it previously. I don't know when.
Were you familiar with its contents?
I read it once, yes.
Were you familiar with the language attributed to you by Ms. Bell in that declaration?
Yes.
Was any of that language the subject matter of the questions put to you by counsel?
They did not use that language, no.
What language did they use instead to help you with the Bell problem?
They used the term racial slurs.
Okay. Well, now, do you have any memory of even one of these 10 questions?
No.
Not a single one.
No, sir.
And this happened when, Detective Fuhrman?
I believe it was 2 or 3 weeks ago.
2 or 3 weeks ago.
Yes.
Well, now, you have been exhibiting a startling memory for detail of a crime that was 8 months ago, have you not?
Sustained.
Did any of the questions require you to say whether or not language of that sort was a part of your vocabulary?
I might have offered that.
Tell us, please, what it was you offered these lawyers in that room about your vocabulary, Detective Fuhrman.
That
Overruled.
Would you answer, please?
Yes. That I don't use any type of language to describe people of any race, such as what is alleged by Kathleen Bell.
And you never have? Is that right?
Sustained. That question's irrelevant.
Did you say to the lawyers who were trying to prepare you for the Bell problem that you never used that language?
It wasn't asked, sir.
Withdrawn. I'll be more specific. Did you tell the lawyers in that room that you never used the word nigger?
Overruled.
It was never asked.
I'm asking, do you?
Do I what?
That's vague. Rephrase the question.
Do you use the word nigger in describing people?
Presently.
Yeah.
Overruled.
No, sir.
Have you used that word in the past 10 years?
Not that I recall, no.
You mean if you called someone a nigger, you have forgotten it?
I'm not sure I can answer that question the way you phrased it, sir.
You have difficulty understanding the question. I'll rephrase it.
Yes.
I want you to assume that perhaps at some time, since 1985 or 6, you addressed a member of the African-American race as a nigger. Is it possible that you have forgotten that act on your part?
No, it's not possible.
Are you therefore saying that you have not used that word in the past 10 years, Detective Fuhrman?
Yes, that's what I'm saying.
And you say on your oath that you have not addressed any black person as a nigger or spoken about black people as niggers in the past 10 years, Detective Fuhrman?
That's what I'm saying, sir.
So that anyone who comes to this court and quotes you as using that word in dealing with African Americans would be a liar, would they not, Detective Fuhrman?
Yes, they would.
All of them, correct?
All of them.
All right. Thank you. Did you have any other training sessions of this sort?
I'm sorry, sir?
Did you have any other training sessions of this sort?
No.
Did you have other sessions wherein the word nigger was used between you and counsel?
No.
Never.
No.
Okay. Detective Fuhrman, I'm showing you what I believe to be a replica of the flashlight you described as having carried that night, and I wonder if you could tell me whether or not it is substantially similar, or appears to be.
Yes, it's exactly.
Appears to be marked. May this just be marked for identification or in case it's used later on?
10:55.
I realize it's light in here, Detective Fuhrman, but would you check that and see whether or not, by rotating the head of the light near the bulb, it turns on and off and also changes its projection? Can you just point at a dark corner under the witness?
Yes, it does, sir.
Appear to function about the same way?
Yes, sir.
All right. Would you narrow the light to a spot? Okay, would you shine it on the screen? All right. Now, would that light in darkness, Detective Fuhrman, enable you to see for a distance of 10 to 15 feet, do you think, to see an object?
I could see the object at that distance without a light. With the light, yes, it would aid me greatly.
No, in total darkness.
I wasn't in total
I
darkness.
understand.
Yes.
Well, I don't think you know yet what I'm talking about, which place and time. Or have you assumed that I'm talking about your visit to the north fence?
No, I'm not assuming that.
Assume it.
Assumed.
Yes. Now, my question is, when you were at the north fence and you saw the glove that you referred to, perhaps mistakenly, as them in your preliminary hearing, were you able...
Sustained. Rephrase the question.
You saw one glove there, correct?
Yes, sir.
Did you look around the area at all in any way?
What area is this, sir?
The area near the fence. The glove was almost at the fence, was it not?
No, it wasn't. It wasn't even close to the fence, sir.
What was it close to?
It was close to the sidewalk.
All right, but wasn't there some railings nearby, near
No.
Goldman's body?
Yes. By Mr. Goldman's body, but not by the glove and the hat.
Do you recall saying that leaves were cascading down over the glove, making it difficult to see?
Yes, there was a plant that had leaves that went up and then fell down a broadleaf plant, and it covered portions of it. It was still visible, but it was clearly visible from the other side
All right.
of the north
Could
fence.
you see that without the aid of a flashlight?
You could see the objects, but not as well as you could with a flashlight.
All right. If you had shined that flashlight on that glove, the left-hand glove, would it have illuminated it better than the ambient light was doing?
Yes, sir.
Okay. Now, will you describe the terrain immediately around the crime scene? And I wish you to eliminate the sidewalk, which is a concrete or terrazzo inlay.
Are you talking
Yes. But what do you have? Do you have grass? Do you have plants? Do you have shrubs?
around Mr. Goldman?
No, around the area closed off by the fence being the one against which his body was kind of propped.
That's Mr. Goldman.
Yes.
Dirt, large tree by, I think, by his hip, buttocks area. Large meaning maybe 3 or 4 inches in trunk diameter.
Was there any other plant life growing in that area?
There was plant life, but I don't recall exactly where it was.
Was it similar to the plant that was partially covering the glove and the cap that we have seen in several pictures?
I don't recall, sir.
Did it stand about that high from the ground?
Indicating about, what,
I'm
10,
sorry,
12
Your Honor,
inches?
yes, about 8, 10 inches or more from the ground.
Which plant are you talking about
I'm
now?
talking about plants that were growing outside the fence enclosure where the crime occurred and adjacent to it.
Overruled.
I can't remember all the small plants that were in the area, no, sir.
Okay. Well, can you tell me whether or not immediately adjacent to that fence and in the general vicinity where the cap and glove and Goldman were located, there were plants sufficiently high to conceal another object the size of the glove it had been lying there?
Objection, that's vague, confusing, compound.
Overruled.
I couldn't speculate on that, sir.
When you arrived at the scene that night, and I'm looking for something, so we'll come back to this and perhaps give you some help on your recollection. When you arrived at the scene that night, were you wearing a coat, jacket of some sort?
When I first arrived at the scene, yes.
Can you describe it?
Blue blazer,
And you were wearing the trousers and shirt that we see you in with your weapon in the picture pointing at the left-handed glove?
yes, tan
Is that-
slacks.
Okay. Now, at some point, did you walk back to your vehicle and take off your blazer and hang it or lay it in the vehicle somewhere?
Yes, sir.
Okay, can you tell the court and jury about what time of day that happened, bearing in mind that you arrived at about 2:10?
It would be after I was relieved from the case.
All right, that would be close to 3 o'clock.
Yes, sir.
And that's when you walked back to the vehicle and left the jacket and stood waiting for your relief,
Yes, sir.
correct?
Yes.
I'm going to show you what has been marked for identification as defendant's 1056, which is a photograph that you may recognize. Would you look at the monitor and tell me whether or not that is a scene that you have viewed before? Back it up. Does that depict the entrance to 875 Bundy with Nicole Brown Simpson's body lying in the rear?
Yes, it is, sir.
Your Honor, I assume the feed is off. I should have.
Yes, it is.
Before. Now,
Mr. Harris warned me.
does that help you to recall the nature of the shrubbery which was to the north of the entrance walkway at 875 Bundy on that evening?
It didn't appear that way from the fence, no.
Well, did you ever stand in this vantage point on the sidewalk on Bundy, looking west?
Yes.
Okay. When you first arrived there, I believe in a similar photograph, you explained that you and Detective Phillips, together with Officer Risky, approached the gate post, which we see in the photograph, by going through the shrubbery off to the left of the photo and then entering the area shown by the photo and walking up to the gate post.
Yes, sir.
Correct?
Yes.
That would have given you ample opportunity, I take it, to view the shrubbery on the north side of the walk from a distance of a couple of feet. Did it not?
Not really, sir.
All right.
If
My
I-
understanding is you're at the gate post. Can you put an arrow on that, please? Just to make doubly certain that we're talking about the same thing. When you referred earlier in your direct testimony, Detective Fuhrman, to the gate post beyond which you could not go without risking the contamination of evidence, is this the approximate area that you meant?
Yeah, a little more to the right, sir, was where Officer Risky was. In that area, yes.
Okay. From there, did you have a view across the walkway at the shrubbery that we see in the photograph?
In the photograph, yes, sir. This shrubbery, yes.
Were you suggesting that this shrubbery is different than the shrubbery that existed on the morning of June 13th?
No, if I could see a picture of from the north residence looking toward Mr. Goldman's body in a southerly direction, it would be easier to explain.
We are going to try and locate one, but for purposes of your present examination, can you tell me whether or not, from the position you were standing, if you looked across the walkway in a northerly direction, you could judge the height of the shrubbery that we see in the photo?
Yes, sir.
And was the shrubbery that we see in the photo substantially the same as what you saw when you arrived at 2:10 a.m.?
Yes, sir.
And would you agree that that shrubbery is fully capable of hiding small objects that might be dropped into it?
Yes, sir.
All right, thank you.
Overruled.
May I approach the witness, Your Honor? Fuhrman, before displaying it, I would like you to look at this photograph and tell me, if you can, whether or not that was taken looking in a northerly direction from the walkway at the base of the stairs in the approximate position where Nicole Brown Simpson's body was after the bodies had been removed.
Yes, sir.
Okay. The area to which I was attempting to direct your attention is on the right or east side of that fence. Now, in looking at that photo, does that refresh your recollection as to whether the glove and the cap were found close to the fence?
Yes, sir. You're talking about this fence that runs north-south.
That's correct.
Yes.
Okay. And you recognize this as being the area where Mr. Goldman's body was found when you were there?
Yes, this is the area I was referring to as somewhat cleared out.
May this be marked?
All right, People's 1050, excuse me, Defense 1057.
1057, Your Honor?
1057. Arrow on that.
I would like the arrow, Your Honor, so that I can point something out to the witness.
All right, proceed.
Detective Fuhrman, we are now looking north inside the crime scene area after the removal of the bodies, or at least the body of Mr. Goldman, correct?
Yes, sir.
All right. And would you point out in that photo, and I'll ask Mr. Harris to put an arrow on it when you do, the area where the left-hand glove and cap were found?
Yes, sir. That's the area right there.
Okay, so that is fairly close to the fence, as I suggested, but you had in mind a different fence when you said it was not, right?
Yes, sir. I was talking about the north fence.
The north fence?
Yes.
And we are talking now about the east fence.
Yes.
Now, what I was trying to learn is this. Number one, would the spot of your flashlight in the ambient light conditions coming from the house, I guess, you fellas hadn't artificially lighted anything when you were there with spots and floods, had you?
No, sir.
Okay, you were operating with flashlights and whatever light could be gained from the open door of the house?
Yes, sir.
All right. With the little flashlight that you have been handling, been capable of illuminating the area immediately outside the east wall of that fence, which is on our right as we look at the photograph?
Yes.
Okay. Thank you. Take it down. We neglected to print 1056 with the arrow where Mr. Harris put it next to the, I'm sorry. Mr. Harris is ahead. It is printed. May that be 1056A, Your Honor?
1056A.
And the other one then would be 1057A.
Yes. Hard copies of each.
Detective Fuhrman, as best you can from your recollection, could you go through the meetings that you had with prosecutors since January 1 and simply tell us who was present and how long they took?
I've met with Mr. Darden.
All right, start with the first one you can recall. Do you have any date in mind as to when this first meeting with Mr. Darden might have taken place?
I believe I probably met with Miss Lewis before Mr. Darden.
Miss Lewis?
Yes.
Okay. And could you tell us when that occurred?
No, sometime this year.
Within the past week?
Well, I've seen her frequently because she's in the DA's office, but not all of the contacts were talking about anything to do with testimony.
Was any one lawyer at each of the meetings where testimony or the case, either one, was discussed?
No.
The first meeting that you had with Miss Lewis, when would you estimate that it took place? In January, February, or March?
I'm not sure, sir.
You can't tell us whether it was more than 3 weeks ago or less?
Well, I've talked to her several times over several months.
I appreciate that, but I'd ask that you use your best memory to inform us of when you first met with Miss Lewis about this case, testimony or otherwise, and how long that meeting was.
I'm not sure. As far as motions, it could have been, I met her last year or talked to her on the phone, but I don't recall exactly.
Did you or didn't you meet with the prosecution last year about the case after the preliminary hearing?
I did not. I did not.
Well, what did you mean when you said, I may have met her last year over the phone or otherwise about some motions?
Well, I might have been asked about something that's no longer part of this trial or a motion that I get phone calls, sir. I don't write them down. I don't log them in. I don't know what to tell you.
You're a detective who doesn't always take notes.
I don't take notes about phone calls, or that's all I do.
Okay. Well, how many times did you speak with the prosecution on the phone as opposed to personally about this case, starting in 1994, if you can?
I've talked on the phone with prosecutors about when we could get together or meet, and that's kind of difficult because of the scheduling.
All that aside, Detective Fuhrman, when did you talk with a prosecutor about a motion in 1994?
Sir, I don't have a day calendar. I don't have a day calendar. I write those memos in.
I understand, but you have a memory. You remember this crime occurred in June of 94, don't you?
Yes.
All right. Now tell us as best you can, what was the motion that you were discussing on the phone?
Sir, there's been so many things going on with this, I couldn't tell you when I talked to some people about.
Didn't ask you that. What was the nature of the motion that required that you be consulted, if you know?
I don't, sir.
Was it a motion about Kathleen Bell?
You can
I've
answer.
talked to
You can answer the question.
I've talked to Miss Lewis about Kathleen Bell's motion, yes.
All right. And was that in 1994 when it was presented or filed?
It could have been.
All right. Did you talk on January 3rd when it was argued? Or thereabouts?
I don't recall a date, no.
All right. Were you in the prosecutor's office in the month of January?
I believe so, yes.
On what occasions? And start with the first one, please.
Sir, I cannot remember a date. I couldn't give you a time.
You kept no record whatsoever of your visits.
Why would I do that?
Were you on duty?
Yes.
Did you have to account for someone as to where you were going and why?
No, when the DA's office wants to talk to a detective, they obviously will talk to him. There's nobody that would need to give me permission. I just say I'm going to the DA's office.
Well, who would you tell? Someone had to know where you were, didn't they?
Yes, sir.
Well, who's your boss? Detective
Ron
Phillips?
Phillips.
Okay. Did you tell Detective Phillips on those occasions when you were coming downtown to work on this case where you were going?
Yes.
And do you know if any records of any kind are kept about these visits?
Not to my knowledge.
Were the prosecutors keeping any records of your visits that you know of?
I don't know, sir.
All right. Now, do you leave it with the court that if you had a meeting with Miss Lewis in January, you are not certain of it?
That's correct.
You just don't have any memory of meeting this woman in January, the one seated at the table here to my far right.
Sustained. Rephrase the question.
Okay. Try again. Did you or did you not see Miss Lewis in January in this building?
I'd say I could have, but I couldn't tell you exactly when, so I can't say for sure.
Is she the first lawyer that you met and talked to?
After the prelim?
In 1995. We'll just leave 94 alone for now.
I don't know if she's the first, sir.
You don't know.
No.
Does anyone else come to mind as being the person who started off this whole series of interviews?
No.
Was it Mr. Darden?
No.
Was it Ms. Clark?
No.
Any other lawyers not seated here today that you've worked with on this case?
No.
Mr. Hodgman?
No.
Okay. So January, then, I take it, is a blank.
No.
May we now turn to February. Do you have any memory of coming to this building in February and meeting with someone?
Yes?
When was the first meeting in February that you can recall, Detective
can't.
Phillips?
I can't recall when in February.
I'm not asking for a date in a minute. Can you say early, middle, late? Give us any help at all?
I'd say it would be fair to say probably early part of February and the latter part.
All right. Who was present at the meeting, the first one?
I've talked to Mr. Darden, talked to Ms. Clark, I've talked to Ms. Lewis.
Does that mean you cannot remember who was present at the first meeting?
That's correct.
And that was early in February, you think?
Yes.
Okay. When was the one after that?
I'm not sure, sir.
Early, middle, or late? Can you help us at least that much as to meeting number 2 in February, Detective Fuhrman?
Sometime in the latter part of February.
All right. So you had a meeting in the early part of February, being the first one of that month, and you don't remember who was at that meeting, correct?
No.
And then you had a meeting at the latter part of February, with whom, if you recall?
I've talked to all these prosecutors that are seated before me.
All at once?
No, they work a team. I could talk to one, I could see another one the next day or the next hour.
Well, let's try and approach it another way. Of the 3 prosecutors facing you, with whom did you spend the most time talking about the case?
Probably Ms. Clark.
When's the first time you can remember seeing Miss Clark in a meeting that you attended in this building? In February?
I believe in latter part of February.
Okay. Do you remember how long the meeting was?
We didn't have many meetings or discussions that lasted much longer than an hour once we got started.
Do you remember the day of the week that the meeting occurred?
No, I don't.
Do you have any memory of the time of day that the meeting occurred?
It would be after court or maybe an afternoon on a weekend, but I can't remember that period of time or day a week with the person.
Can't remember.
No.
Okay. When was the next February meeting you had after number 2 late in the month with Miss Clark?
Sir, I don't know.
Don't know.
No.
But Detective Fuhrman, when I asked you if you'd had 10 meetings and you said 8 would be more like it, where did you get that number?
I just felt 10 was too many. It just felt like I'm more comfortable with 8.
Well, did you pick 8 out of the air, or do you remember having approximately 8 meetings with prosecutors?
Sustained.
Did you have a memory when you gave us that answer of about 8 meetings with prosecutors?
Overruled.
That felt like a comfortable number, yes.
All right. Why did it feel comfortable?
Because it was more than 5 and less than 10.
So far, you've described 2. Are there any more meetings in February other than the 2 that you've described that you can recall now, Detective Fuhrman?
I can't recall the specifics. I didn't take note of these. Many times it was inconvenient, and sometimes we got nothing accomplished because of scheduling and things going on with people's personal lives. Sometimes they were not much of meetings at all because of people's lives.
And were there some times when disagreements prevented anything from being accomplished?
I don't recall that.
Don't recall having any disagreement?
No.
All right. Now, how about March? Do you recall some meetings in March?
We have met, yes, in March.
The first one in March that you can recall, and I assume that it would have to be early or middle.
Yes, early in March.
Okay. Any idea what date?
I believe it was on a, I don't know the date, it would be on a weekend.
A weekend in March.
Yes,
All right. That'd be the first weekend in March if it was early in March?
could have been.
Was it down here?
Yes,
Do you recall a Saturday or a Sunday?
I believe it was a Saturday.
And who was present?
Miss Clark,
How long did you talk?
about an hour, hour and a half.
Was anyone else present during that hour to hour and a half?
People came in and gave her messages or papers that I didn't know what she was receiving, and then they left.
All right. But were any of the other lawyers seated at this table or other lawyers working on this case outside the courtroom present during this hour to hour and a half?
Periodically, an attorney would come in and give her something. Sometimes they would stay for a moment, then they would leave.
Well, let me narrow it a little bit, Detective Fuhrman. During this hour to hour and a half, did any lawyer connected to this case come in and participate in what you and Ms. Clark were doing?
No.
All right, so that you talked together for 60 to 90 minutes about
Yes.
the case.
Yes, sir.
None of these people have ever had conversations with you about other matters, have they?
What are other matters?
Other than the case?
Overruled. You can answer the question.
I don't understand the question.
All right, let me rephrase it. You have told us that you spent a number of hours talking with these people, among others, about the case.
Yes.
You don't socialize with any of these lawyers, do you?
No.
Haven't seen them outside the work environment, have you?
No.
And you don't have any other cases going with them at the moment, do you?
No, sir.
Okay. So is it fair to say that all of the discussions you have had with these people in 1995 have been about the case?
No.
It's not?
No.
What other things were talked about?
Chris Darden and I talked about basketball.
Okay,
Miss Lewis talks about scuba diving.
all right. Were these dominant themes or just small talk as part of the overall conversation?
Just conversation.
All right. But the main purpose, I take it, of each encounter, even though there may have been other subjects touched upon, was the case, People against Simpson,
Yes.
and your role in that case.
Yes.
Now, the total number of meetings in March that you can recall, excluding the grand jury session.
2 or 3.
All right, the first was with Ms. Clark for 60 to 90 minutes. When was the one that you meant when you said 2?
I believe that was during the weekday after court with Miss Clark.
And when was that?
I believe the following week.
So if you met on a Saturday, then some day during the following week after court had adjourned. I take it was late in the day.
I believe so, sir.
And how long did that session last?
I recall it was about an hour.
And were any other lawyers involved to the extent of participating in that conversation that you were having?
I think periodically Miss Lewis came in and out.
Did she stay long enough to position herself in the conversation or just drop something and take off?
Well, a lot of times when another person comes into the room, Miss Clark will stop, take care of business, or wait till they leave, and then we continue.
All right. My question to you was Ms. Lewis assisting Ms. Clark in some way in the preparation for this case, or simply coming in and out on other matters, other
No.
than the Fuhrman testimony?
No,
Okay.
Miss Clark dealt with me directly.
And you said 2 or 3. If there was a third, what's your recollection as to that?
Close to the beginning of my testimony, or close to that week.
Your testimony began, I believe, last Thursday.
Yes, sir.
So how long prior to that was your meeting with Ms. Clark, if it occurred? I'm now looking for a third one.
Yes, that was very brief.
Yes. How long prior to the onset of your testimony did it occur?
2, 3 days?
Not the day before?
I don't believe so, no.
You weren't in the building the day before?
I was in the building the day before, yes.
What were you doing?
Waiting to testify.
Not talking with anyone?
No.
Was your lawyer with you at the time?
No, he was watching the TV, and I was not.
Now, have you spent any time with him, without going into anything that was said, preparing for your testimony in this case?
Preparing for direct testimony in this case?
No. Preparing for the cross-examination you assumed would follow hard on the heels of direct?
I think I've gotten some general advice, much the same as I've gotten from most of the people I know.
Okay. And you have been urged to remain calm, have you not?
I'm going to sustain the court's own objection in the context of the previous
I'm sorry.
question.
I mean to exclude Mr. Tortolo from any question that has substance of a conversation in it. I do not ask to go into anything he said to you. But you mentioned that you had advice from a lot of people, and what I meant to ask you was, did a lot of people say it was very important to remain calm?
No.
No. Were any documents, books, or other materials given to you or exhibited to you at any of these sessions to assist you in your role as a witness in this case?
No.
You have read no books on how to be a good witness?
No.
None on cross-examination?
None.
Have you watched any films or tapes that relate to that subject?
None.
And have you discussed your position with fellow officers and sought their advice as to how to be an effective witness?
No.
Now, Detective Fuhrman, is it not fair to say that in your 19-year career, this is by far the most important case in which you've been involved?
Yes.
Is it not also true that you realize now, as you did back on June 13th, that the right-hand leather glove, which you claim to have found in Rockingham, could be a very significant piece of evidence in this case?
Yes, sir.
And are you aware of the fact that your testimony, as it pertains to that evidence, may be very, very important to this court?
Yes.
Did you anticipate, based on what you had been told, that some sort of attack might be visited upon you with respect to alleged racial slurs?
No.
Was it a surprise to you when those questions were put by Marcia Clark at the very outset of your testimony to give you a chance to deny the allegations before I have talked to them? Withdraw the question. Do you recall that when you took the stand, you explained to the jury and to the court that you had had some special sessions because of a problem not related to the facts of the case?
Overruled.
You recall that?
Yes.
All right. Do you recall that Ms. Clark then caused to be displayed to you parts of a letter allegedly written by Kathleen Bell to Johnny Cochran and invited you to examine the text of that letter? Do you remember that?
Yes, sir.
Okay. Had you discussed the fact that this was going to happen before you ever came into the courtroom?
Yes, that part, yes.
This was no surprise to you, was it?
No, sir.
And were you not advised that the effort in doing so was to steal the thunder from the inevitable cross-examination?
Sustained.
Was it explained to you that this was an effort to defuse the impact of any accusations that might later be made against you?
Sustained.
Why, if there was an explanation, was it explained to you that this method of introducing your testimony was to be used in this case?
It wasn't explained to me, no.
Well, in other words, as I understand it, you were simply told, here's what we're going to do, Detective Fuhrman. Here's the order in which things will happen when you hit the witness stand, and we're not going to tell you why.
I'm not the prosecutor, sir.
I know that you're not the prosecutor, you're the witness.
That
Did
was
you
what-
have any comprehension as to why this tack was taken by the prosecution?
Yes.
Did you understand that it related to possible experiences you might have on cross-examination?
No.
Okay. What was your understanding as to why this letter was surfaced at the outset of your testimony?
I think his frame of mind is relevant. Overruled. His understanding,
His
no,
understanding.
I've inquired, counsel. It is relevant, his frame of mind. Overruled.
Give us your understanding of why this was done in this case.
Because that's why Ms. Clark, the way she wanted to litigate this case.
Okay. And beyond that, you had no comprehension as to why it was done. Is that right?
No.
Did you not testify at the very outset of your testimony that you have been subjected since the preliminary hearing to a barrage of personal attacks which made you nervous as you first sat down in the stand?
Sustained.
Did you tell us something about your experience since July 6th, or a little later, perhaps around the 14th, that was unusual?
No.
Did you tell us anything about problems you had had that were specific to this case and no other and did not relate to the evidence in the case?
Yes.
What did you mean to convey when you told that to this jury? What were you thinking of when you talked about these problems?
Being accused of committing a felony and a capital crime.
Okay. Was that the only accusation that was troubling you as you took the witness stand?
That's the only one I care about, yes.
The other ones, the accusations that you use racial epithets you don't care about at all, is that correct?
I didn't say them. I don't care about them.
You don't care about them?
I didn't say them, sir.
Oh.
Witness answered.
Yeah. Did you read, without specifying the publication, in one of the media covering this case, a printed article, that disclosed or purported to disclose that you were undergoing some heavy training in the DA's office? Did you,
Sustained. Rephrase the question.
I'm sorry, Henry?
Rephrase the question.
Okay. Did you learn from any source that it was claimed that you were undergoing some training sessions in the district attorney's office with several lawyers?
I was told that.
Okay. Do you remember when you were first told that?
I believe when that Newsweek article came out.
So, Newsweek, you read it?
No.
No. Who described it to you?
Miss Clark?
Did she
Miss
read
Lewis?
it to
Yes.
you? They
Read
read
it
you
to
the
me?
text?
No.
Okay. Was there any talk, this, by the way, occurred after the grand jury experience, did it not?
Yes, sir.
Was there any talk during the period when she was reading this to you about a leak?
Wait.
I'm sorry. I may have misheard you. Did you not just tell us
Rephrase the
Ms.
question.
Clark read you the Newsweek article or a portion of it?
I don't believe she read it. No.
What did she say to you that Newsweek was talking about?
She pulled out excerpts of the article.
Well, where were the two of you?
Sitting in her office.
Okay. Now, does this help you with one of the meetings, the recollection of the Newsweek article in March?
Help me with the recollection.
We were trying earlier, Detective Fuhrman, to pin down as best we could the times that you had met with prosecutors in the month of March to get ready for your testimony.
Yes.
At which of the possible 3 meetings that you have some recollection of did the Newsweek article surface?
I don't remember which one it was, sir.
Well, you remember the date on which you did the grand jury thing?
No.
You remember the day of the week?
Sunday?
Sunday?
I believe so.
All right. How long after that did Ms. Clark inform you that Newsweek had described the event?
I don't remember that.
A day or more?
I don't remember, sir.
All right. Is it fair to say that when Ms. Clark informed you about the Newsweek piece, it was after the grand jury exercise had taken place?
That would be fair to say.
All right. Now, were you present in her office when you learned about this? Or on the phone?
I'm not sure on that. I could have been in her office.
You don't recall whether or not you were on a telephone or facing Miss Clark when you learned that your grand jury training had been published in the media?
I don't remember, sir.
Don't remember. All right.